Welcome to Books for Beneficiaries. My name is Pete Williams, the host of the program on which we talk about the needs of beneficiaries. In estate planning matters, it is the estate owner that takes center stage, and that, of course, is appropriate. It is, after all, their wealth. However, the beneficiary sometimes is left in the dark as to the process. They have needs and questions. They want to ensure that they have their proper inheritance. So I am hopeful that this series will shed some light and give them some information that will help them. I call this series Books for Beneficiaries. So stay tuned for the next chapter and check back for more to come. So hello and welcome back to Books for Beneficiaries. My name is Pete Williams, the host of the program. And I thought what I would do today is talk about something called a testamentary trust. You know, we talked about probate and wills in a recent episode. And for the most part, what happens when a probate goes through, assets are simply distributed. But that's not always the case. The cases in which assets are not distributed, but they're held for the beneficiary. So I want to talk about the testamentary trust, what it is, when it comes into existence, how long does it last, how it differs from a living trust, and what are the tax ramifications. But first, let's talk about what it is. Well, it is a three-party arrangement in which you have someone who creates the trust, funds it typically. It's their wealth. They put the money in. Then you have a trustee who has the responsibility of managing that trust, those assets. And then you have the beneficiary to whom the assets are paid. So it's a typical trust arrangement. Creator who creates a trust, they name a trustee for the benefit of somebody. As the name might hint, is a trust that is created at death, and it's created through a will. There are cases where a testator, somebody who writes a will, says, hey, you know what? I don't want assets to go outright to my children. I want assets to be held in trust. And that trust is confirmed through a probate process because it comes about through a will. The settlor or trustor might want to hold assets back for inheritance. So if you're a beneficiary out there and you're thinking the typical case where, hey, mom and dad die, assets are distributed, and I'm going to get my share right away. Not if they create a testamentary trust. So how long does it last? Well, it lasts as long as the creator wants it to last within the bounds of the law. There are certain laws that say you cannot create a trust for too long of a period of time, and this differs by state. It's called the rule against perpetuity. Many states have rules that says, hey, you just cannot create a trust that lasts forever. So there's got to be an ending term to a trust. It does become irrevocable because the person who could revoke it is now deceased. And it may contain certain provisions which define how long it is to last. It may be by ages, and this is often used to protect younger beneficiaries. So let's just say grandma and grandpa want to leave some of their assets to a grandchild who is a minor. They might say, hold these assets in trust until the minor grandchild turns 21. It may be over a period of years. Many times a windfall of assets is the worst thing you can do to a beneficiary. So somebody inheriting $3 million all in one day can be devastating because they're not used to having that much money and they don't know what to do with it. And in 2 or 3 years, the money's gone. There's plenty of stories out there. So what a testator might do is say, when I die, create a testamentary trust, immediately pay out 25%. And then in another 5 years, pay out 33 and a third percent, 1/3 of the assets. And then in another 5 years, pay out half. And then finally, in another 5 years, pay out the rest of it. You could also have a testamentary trust as what's called a unit trust that says pay out 5% of the assets. to the beneficiary. So the instructions of the trustee are to calculate the value of the trust on December 31st, and then in the following year, they pay out 5% of that value, and they do that every year. In theory, the idea sometimes is that the assets are worth zero or close to zero upon the death of the beneficiary. However, there might be something left over, so they have a contingent beneficiary to the primary. There are also cases where the creator, let's just say that the creator are the parents, and they struggle with a child that um, may have difficulties in life. So they instruct the trustee, pay out to the beneficiary only if the child is gainfully employed, is doing charitable work, or is full-time in school. So they want some incentive to the child that may have had difficulty during their lifetimes with those factors. It could be drug use. The trustee is instructed to pay out a certain amount or a certain percentage if the beneficiary is drug-free. And it makes it difficult for the trustee because the trustee, of course, has to take the beneficiary down to a medical facility to prove up that they are drug-free. It may be marital conditions, and these are more difficult sometimes, but the parents may write a will and they may leave assets in trust, but they want assets to stay in bloodline. They do not want assets to go to a child, and then if the child dies, it goes to the spouse, the daughter-in-law, let's say. And then upon daughter-in-law's death, it goes through their bloodline. This all often assumes there's no grandchildren in the picture. So they may struggle with that, and they may have provisions about how to leave assets when they're uncomfortable with the marital status of their beneficiary, their child. We've all heard of the so-called revocable living trust. How does the testamentary trust differ from the living trust? Well, once again, the title gives it away. A testamentary trust is created upon death. It does not exist prior to death. A revocable living trust is created during life, and it has provisions, lifetime provisions, usually to take care of the settlors, the creators of the trust during their life, and upon their death, then it goes on to the beneficiaries. So when the settler creators die, it typically is cast in stone. Now, there are some provisions that the creators can use to make changes because circumstances change. And there are tools, and it changes by jurisdiction, by state, that you can actually make an otherwise irrevocable trust somewhat revocable or somewhat changeable. Another important distinction between a testamentary trust and a living trust is the tax ramifications. Typically, with a living trust, it is a pass-through entity. The income is reported to their Social Security number. The trust does not have to have a tax identification number, so it just passes through. When a trust becomes irrevocable, then it requires its own tax ID number, and it is a separate tax-paying entity. So there's a trust tax return, and the trust generally pays tax on income that it does not distribute during the year. And by the way, trusts pay a much higher tax, believe it or not, than people do, simply because of the lower threshold for when taxes are owed. So just to continue with the tax ramifications of a testamentary trust, mom and dad die, they leave a will to create a trust. As long as the trust is around, it's its own tax-paying entity. And the other important thing I want to point out is that there is no step up in basis on the beneficiary's death. Let's very quick review. When an owner has capital gains during life and they die, there's no tax on the capital gains. It's called a step up in basis. And so up to date of death, there's no capital gains tax. There is tax after that. But in the case of a testamentary trust, it's an irrevocable trust, which is a separate tax ID. So In the one case, if you gave the capital assets to the beneficiary and they die, you would have a step up in basis, all capital gains forgiven. If you have a testamentary trust and the beneficiary dies, there is no step up. The owner is the trust, not the beneficiary. So there's an important distinction between owning a capital asset outright or through a revocable living trust and getting a step up, and having assets in an irrevocable trust, such as a testamentary trust. When the beneficiary dies, there's no step up in basis. All right, that was very quick. I just wanted to make sure I got that out because I was thinking, hey, wait a minute. I just spoke about wills and probate. I hope I didn't leave the impression that all assets just go out and distributed outright. You do have such things as testamentary trusts where they keep assets in trust over a period of time. So I want to thank you very much. And once again, for beneficiaries is not intended as legal, tax, or investment advice. If you need that type of advice, you should seek out your own personal attorney, accountant, or financial advisor who knows your personal circumstances. So until next time, take care and look forward to talking to you again about the needs and rights of beneficiaries.